I would like to ask Vittorio, how does he see the future market for Italian shipping lawyers?
This is really a very good question.
Is a counter-cyclical.
I think that any lawyer is certainly nowadays a little bit upset about the economy, even if in the shipping, because the good days are coming when everybody is getting better, not worse. So also for the lawyers, I think we all expect good days for the ship owners more than bad days. No one is like to work on the tragedy, but possibly on the earnings of the clients. So, I mean, let's hope that everything is going to go well very shortly. As far as the private equity, you are speaking about funds, no? Of course, who are the people who are financing the funds? I am expecting banks, also financial, but also persons. Also person. If I wish to invest some money in your fund, I can.
In fact, I pointed out before that unfortunately the appetite for the risk or the aversion to the risk for these players is huge now.
No, I do understand the difference between a loan and an equity. The equity is a risk. But of course I am prepared to run the risk upon certain conditions, which according to me are two conditions: trust and transparency. Now, because I invest my money in your fund, and I must rely on the skill of the people working for the fund and how they are investing our money. Now, which kind of control I may have in a fund, for instance, in the governance of the fund, if I am investing a substantial amount of money. I mean, I am not speaking 100,000 euro, but for instance, 5 million euro.
So you are a German dentist or what?
No. I am not speaking for myself, but in general.
Just to interrupt, because we are not confused the German KG with the private equity.
No.
Another story.
So what I'm saying is that in order to encourage the investment in equity, in addition to the trust and transparency, it is also very important to know how and when and which condition I can exit from the investment I made, even if I do understand that it is a long time investment, but I must also perhaps one day need to disinvest, at which condition I could. So I think that the three main conditions in order to encourage this kind of private equity should be always trust, transparency, and how I can get out.
I fully agree. We have to be compliant with the three main factors. I think that as before we exchanged some words outside of the conference about the Italian legislation in general, that we sometimes we go too speedy, and we recover more time than the expectations, because as like for the bankruptcy law, we put that in standby for 16 years, and after in 2 years we try to regain the time. It's the same for financial regulations, because due to the scandal, the crisis, we try to recover it, but then the base, the financial matter, the base and the pillars of financial matters are represented by the trust. The trust is the first pillar. Without trust, no money, no funds, no financial industries. I fully agree. I think that we have too much regulations, maybe. But the problem is to change the behaviors and the mentality, like the shipping. We have to improve together.
Thank you, Fabrizio. There are some questions from the floor. Please.
Doesn't work? Okay, it works. Sorry for if we are late, we are all tired if I bother Fabrizio and about the discussion about the private fund. I represent a company which is a small company and a very traditional company existing for 5 generations. And we, from time to time, think about possibility to gather money by using other financial than the banks. And what I want to say to the managers of the investment funds is to change the approach sometimes towards the small companies. And first of all, the key is what in Fabrizio said, that the money of the investment funds are lended from banks. And this is something that sometimes does not go at the same, very well with the company's strategy, because in itself they have an interest, to repay and a spread from the bank. So one challenge could be for the managers, for the investment fund, to raise in some way fresh capital. Maybe people wanting to invest their own money and not lending, borrowing the money from the banks and wanting to invest in a small company. This because and also, you have to put together this thing together with a focus on the specific project. I get mad sometimes when I say we are a company operating in the offshore, when they say is it the time to invest in the offshore because it's wonderful. Nothing is wonderful itself. You should, for the investment funds, you should see the project twice and enter into the project together with the ship owner. Because sometimes, for example, I say something against our company. Maybe we are a small company and the offshore is growing in West Africa and it's very difficult for us to go in West Africa. So if we prospect you a big growth of our company by going where we cannot go or we are not able to go, is something which is not good for us, for the investors and for the investment fund. So I would suggest maybe to bother us and to try to enter into our strategy, to put person of the investment fund into the company, to control the, even day by day, the strategy and set the strategy together with the ship owners. And especially, I don't like for the investment funds when I hear about something like I lend you the money, but I don't care about the strategy. You are the ship owners. I don't want to get into it because there is something wrong. If someone invests into a small company, he should participate to the project itself because it's more safe. First of all, and then it's very difficult sometimes why we always speak about investment funds and ship-owning companies, and we see from, in the last years that these two things that don't get along well, is that because many of the ship-owning companies in Italy exist for more than 2, 3, 4 generations, and it's very, very difficult, extremely difficult, that someone will gamble the works of the person coming before themselves. So the work of the father, the grandfather, and whatever. So it's very difficult. And speaking about the exit strategy, try to be to participate for a long period as possible. So 5 years are too poor a number of years, and it's it's not too much time to see a result. Since the companies in Italy exist for more generations and they have provided results to the family themselves, it's now the moment for the funds, I believe, to be more patient and to wait for more years if they can, and to go together on the same path of the ship owners. And they will have a result, maybe by participating a little bit more, but the anxiety that the ship owners has for the exit strategy is too much for shipping. If you have to consider that if you order a new vessel, it takes 2 years to build a vessel at least, and then the exit strategy is after 5 years, and the first 3 years are the most uncertain years for a vessel. It's almost impossible to repay at the interest rate that the investment funds it wants. So maybe it could be good if somehow the investment fund can raise capital, fresh capital of persons willing to invest in a company and willing to, I'm speaking about the single investors, to know the ship owner and to go there and to participate to the strategy. Because more, I believe, my company, but also other companies can be very, very, very open in the strategies, and they have nothing to hide, and they want people to participate maybe to the strategy if they can bring something interesting to the company, their competence, So just this one.
Thank you for your paper, Andrea.
Sorry if it was too long.
No, it was very interesting. Any more questions from the floors, from the panelists? Please.
Just Francesco, because it's rare that I am among so many lawyers, I want to ask you a question instead of being asked the question. One of the things, and I know Mariella would agree with me, is that on the UK Defence Board, we are often concerned about the discrepancy in the cost between prediction, outcome, and between similar cases from different lawyers. And one of the things that we are considering is, why does it need to be a per-hour billing, and why can it not be a per-case billing in which, there would be more of an alignment of interest along the success of the outcome? And this is one question. And the other question is, if we were driven to arbitration as a way of circumventing the very slow process of the high courts, now that arbitration takes even longer than the high courts, might we not consider going back to them?
Well, I try to answer partly the first question. Now that the Italian professional law allows we recently made some no cure no pay agreement, and very soon we are going to start very important and very innovative proceedings for almost 50 million euro with a no cure no pay agreement. So if we don't get the result, we will not be paid. But perhaps the other lawyers may want to give some answers, also the English lawyers.
I can have some idea.
Okay, as someone who does, I won't. We have William and Jonathan. Sorry.
No, I think that, now that we can, I believe that it is possible to be absolutely flexible, to look at the interest of the client, in the same time to guarantee to the clients that you remains independent. Because sometimes if you work on no cure, no pay basis, of course you have an interest, personal interest, which of course not always is something positive. But when I speak about to be flexible, I mean that any kind of reasonable agreement in terms of fees can be reached with the client. Because, for instance, on the time basis charge, of course you are a little bit penalized when the client is penalized when the amount of the claim is a small claim. On the other end, the lawyer may be penalized when the claim is a big size. Because, as well as, I think it is not fair, if I am a wonderful lawyer, perhaps I can take 10 minutes to solve your problems, and another one can take 2 hours. I don't think it is fair that I charge 10 minutes of work if I am very reliable to solve your problems. This implies that, one should be flexible according to the size of the client, because sometimes also the size of the clients comes into account, the amount in dispute, the issues in dispute, because sometimes it can be not very problematic to solve the matter, so your involvement can be less than in other case. So I think that if we approach the problem under the flexibility issue, I am not expecting any problem with any whatsoever clients to negotiate either on the time basis, either on a cure no pay basis, either on any alternative which may be acceptable for the lawyer, for the clients. I think should be followed now, especially that we are completely free to reach with the clients. We have to. Now our law implies that we have to reach an agreement with the clients, to be signed by the clients. We are compelled to make a general estimate of the total cost at the end, and that this should be accepted by the clients. So, I mean, these allow really to follow the flexible approach, which I think is the best one.
I hate to have see this 10-page or 15-page American colleagues retainer agreement letters. I think this drives me crazy to have with my client already a potential dispute. I don't think this is the way to work, but I totally agree with Vittorio that we should try to be flexible from all the sides. I would like to hear also from my colleagues, and in particular also from Clive. Yes? Fabrizio? No? Do you want to work no cure, no pay as well?
Not my matter. Just
Please.
but even indeed on the lawyer side, so I was interested to get my question about the changing rule regarding the third independent appraisal, and how the change can affect the application of 182 and 186 is a question that I put for Furio and Mr. Porzio and on this topic.
The new law clarified what.
I refer to the change in the criteria because now the independent appraisal has to state not fairly but the feasibility of the plan on one side, and also the punishment became bitter than the past because the new rules established the up to 5 years of custody and the arrest and custody and then the 100,000 in terms of economic sanction.
Yeah, I mean it's the independent expert also considering what is required in order for the expert to be independent in terms of no connection with the debtor, no connection with any person having interest in the restructuring, and the fact that he does not have carried out any activity in terms of labor, or the fact that it shall not have participated in any administrative body of the debtor. I mean, all these independence requirement obviously will make it more difficult for an expert really to be independent. In terms of the certification of the feasibility of the plan, well, it's a very let's say delicate matter when you when you are subject to a criminal liability because of false information or concealment of information and data. So it would be, I think, a very delicate issue for the expert to certify the feasibility of the plan and at the same time not being subject to a criminal liability. It's a very borderline matter. I mean, it's this new liability will probably need to be tested by by criminal cards, but in any case, the role of the independent expert in terms of independency and in terms of criminal liability has become really more difficult and more delicate.
Thank you, Furio. So, any more bullet answer to the question about costs, or we discuss it over dinner?
I just make a couple of things. The dynamic in England is slightly different, as you know, Yanni. First of all, you have costs are generally recoverable by the winning party, which tends to moderate it. Secondly, I would say that the English system has generally set itself against pure contingency fee litigation. And I think if you look at the American experience, you can see the abuses there. So, yes, people are paid no cure, no pay on the result, but I'm not altogether convinced that's the best solution. There is, in the English, and we find you don't, and I don't know the debates you're having within the UK Defence Club, and maybe that one is for dinner, but you will know, Marielle, probably not from the defence side, but your club will know, that a lot of the cargo claims are dealt with by cargo underwriters' lawyers who are on the so-called conditional fee arrangements. And our experience of that, which I think is under review by Lord Justice Jackson at the moment, is not altogether satisfactory because, as a word we used earlier on, in a very different context, transparency. We don't actually know. We will be penalised if we lose the case, and cargo claims are difficult ones to defend, as you know. We are told our case is useless, and then we make a settlement of about 60 or 55%, and find that triggers, quote, success with an uplift of 80%. So, I mean, several points there. I mean, contingency fee out, there is something in the English system that's used by one sector, but not on the ship-owning side. And, you know, as a matter of personal experience, we've actually gone to, particularly the clubs who pay on defence fees, with packages on fixed rates or fixed rates for a stage. And I've been doing this now for 7 or 8 years. And I either get no response, or the response is, well, can you just lower the rates a bit? Which is,
Okay, so any more bullet answer? No, thank you very much.
Francesco.
No.
I would to congratulate. Would congratulate with Mr. Garolla, young Garolla, because
Yes.
he's part of young ship owners, because he demonstrates that the mentality is changing.
Yes. So having changed the mentality,